perform functions the same as or similar to those performed under Section 33 by a court in the state. Helpfully, we don't have Section 33 here. Oh, do we? Where is it? Oh, sorry, I'm told. Oh, wonderful. Tab 140 of the. That's much better. Thank you. Section 33. We go to tab 140 of the supplementary bundle. What you will see is that Section 33 is the section that gives the power to issue the EAW. So the Irish definition of judicial authority expressly includes any person authorised in the issuing state to issue a European arrest warrant.
And certainly, I mean, you're not contending, as I apprehend, that there's any violation of Article 5 in respect of such a scheme.
I'm not, Lord. I'm not, Lord. I'm not suggesting that there is no power in one state to agree to surrender individuals to another on the basis of a warrant issued by a public prosecutor. I don't suggest that. I accept that there is such a power. The point that I make is that it is not a matter that is required by the framework decision, and it is not the legislative choice that was made by the UK Parliament, because the UK Parliament chose a different route, which was to insist upon judicial authority as a safeguard. That's the point.
But doesn't this involve your conceding that judicial authority within the meaning of the framework decision is capable of being as widely construed as the Irish have construed it?
My Lord, no. Because what the Irish are saying is we will deem to be a judicial authority any authority in the member state that has been designated to perform this function. So if the member state designated, for example, a private prosecutor, an individual who wished to bring a private prosecution as being able to issue an EAW, under the Irish statute, that would be sufficient. Or if it was the Secretary of State for Justice, doesn't matter who, or simply a police constable. All that the Irish statute requires is that the person is designated in another member state. That's all it requires.
Your submission is that the framework decision doesn't forbid individual member states going beyond.
Indeed, my Lord, it actively encourages them to do so if they wish. It sets a floor. And it sets a floor of minimum cooperation, and the floor of minimum cooperation is based on an EAW issued by a judicial authority. And of course, one of the parties negotiating that agreement was the United Kingdom, which we submit was not prepared to agree to anything greater.
I mean, I'm not saying it takes it very far, but it just strikes me that the term judicial authority is being interpreted by the Irish. I mean, they think it's a term that is capable of being given this extended meaning. You may say it's extended beyond that it bears in the framework decision, but it's merely a term which is capable of that extension.
Well, but my Lord, if one accepts that judicial authority in the framework decision means any authority designated by the state to issue a warrant, then the term judicial authority is wholly emptied of content, because all that it is saying is the member state may designate any authority it chooses to issue a warrant, and that shall be deemed to be a judicial authority. The phrase judicial there is adding nothing. That's the point.
The answer to Lord Brown's point is that you can define a word to mean anything.
Yes.
In my next sentence, black means white.
Indeed, and the Irish are defining it here to mean any authority that's been designated in a state. But it doesn't, of course, follow from that that's what the framework decision requires. And our submission, for all the reasons I've gone on for much too long probably, is that it can't possibly mean that. Yes. And what is striking is the difference between the 2003 Act in the United Kingdom and the 2003 Act in Ireland.
It's also striking that their executing authority is the High Court.
Well, absolutely, my lady, because you would expect that from a common law jurisdiction. But they are applying a much more trusting approach to their European partners than the UK Parliament chose to do, because the UK Parliament set a clear standard, and that was a standard of judicial authority. Just for the court's note, this provision was considered by the Irish High Court in the case of Alteravicius. We don't need to turn it up. It's at volume 3, tab 34, page 2714 in the electronic numbering. And at page 2721, the High Court reaches the obvious conclusion on the construction of this 2003 Act. So our submission is that you have to look at what the framework decision requires and not what it permits, and that the United Kingdom was only obliged to implement what it required and did so quite deliberately to the minimum extent. And there may be other states that have taken a broader approach, but that has no bearing on the proper construction of the United Kingdom Act. That brings me then to my next topic, which is what are the implications of what we say is the right construction of the 2003 Act for the status of the Swedish prosecutor in this case. And we submit that the status of the Swedish prosecutor is very clear. This is a simple case. And it's a simple case because the role and function of the Swedish prosecutor was expressly considered by the European Commission of Human Rights in the Skutrom case, which we've already looked at volume 6, tab 57, page 3398 of the electronic numbering. And there, as we've already seen, is an analysis of the role of the Swedish prosecutor and a clear finding that the Swedish prosecutor is not independent of the parties, but is a public prosecutor in the sense we understand public prosecutor. The same,
I don't think that's not contentious, is it?
I don't believe it is, my lord. The same message comes over loud and clear from the Swedish evaluation report. This is at volume 11 of the authorities bundle, tab 94. And if a court goes to page 4396 in the electronic numbering, it's page 4 of the internal numbering, you see the heading, the authorities and the legal basis, and there is an analysis there of Swedish courts, the Swedish Public Prosecution Service, the legal department within the Office of the Prosecutor General, and local prosecution offices. And in particular, at the bottom of 4397, local prosecution offices perform prosecutorial tasks and lead criminal investigations. Sweden does not follow the so-called investigating judge model, and Swedish public prosecutors have very strong powers compared with the situation existing in other member states, may decide on any kind of measures during investigations, including coercive measures, with some exceptions, e.g. phone surveillance or detention. And then the National Police Board, which as we know is authorised to issue conviction warrants, is dealt with at page 4398. It's a central administrative and supervisory authority to the police service, headed by the National Police Commissioner, who's appointed by the government, and responsible for international police work and the central police records. The National Police Board is responsible for issuing EAWs in conviction cases. Now, we submit that there is no possible interpretation of the framework decision under which the Swedish National Police Board could be considered to be a judicial authority. Even if the divisional court in this case was right to take as the start and end of this case the original commission proposal with the definitions that were contained in it, that proposal made it clear that it did include public prosecutors, but it didn't include police. So on any view, Sweden has failed properly to implement the framework decision. The only question is how badly. Sorry, before I leave that, there's just one more point. Going to page 4401. there's a description here of the Swedish law in relation to the issuing of an EAW. It's page 9 of the internal numbering. In issuing an EAW, the Swedish authorities apply a proportionality test. An EAW may only be issued if it's justified, considering the nature and seriousness of the crime and the circumstances in general, thereby taking into account the harm to the individual and the estimated time and costs that may follow. If the requested person is under 18, an EAW may only be issued if it concerns serious criminality or the youth has a strong connection with Sweden or some other special reason for requesting a surrender to Sweden. In prosecution cases, it's the responsibility of the prosecutor to assess whether or not it's legal, appropriate and proportionate to issue an EAW. Now, the reason I show that to the court is that there was some suggestion before the divisional court, and there is some perhaps tentative suggestion in Miss Montgomery's case, but there's no problem in substance in this case, because even if the Swedish prosecutor is not a judicial authority, a detention order had been made by the Svea Court of Appeal, and all that the Swedish prosecutor was doing was converting that to a European arrest warrant. Now, we submit that that is wrong as a matter of principle, and under Swedish law it is quite clear that there is a further discretionary judgment to be reached, a proper evaluation to be reached, concerning the proportionality not of detaining somebody, but of requiring their extradition across a frontier. And that is a different decision from the issue of a detention order.
It wasn't quite clear to me whether under Swedish law it was a condition precedent to the issue of the European arrest warrant that a detention order should be obtained from the court in absentia.
Well, that's not clear to me either.
I couldn't quite see the point of going to the court.
Maybe Miss Montgomery can clarify. She says that was the evidence.
Yes, I suspected that was.
She says what?
She says it is a condition precedent rule. I'm not in a position to dispute that. But whether it is or it isn't...
There's a court order for detention.
For detention. But whether it is or it isn't, this provision makes it clear that there is a separate question, which is not whether a person should be detained, but whether they should be extradited. That's a different question. Can I now turn to the divisional court decision itself and identify what we submit are its flaws? That decision is in the core bundle, page 141. And the reasoning on this issue begins at paragraph 33. It's page 150 in electronic numbering, page 16 of the hard copy. At paragraph 33, the court summarises its task to interpret the 2003 Act in accordance with the guidance of the House of Lords. We don't disagree with that. Then at 34, they say they don't gain much assistance from Hansard, given the broad category of authorities and the practice under the 1989 Act to which the ministers referred. And they refer to the case of Van der Holst, in which a public prosecutor to the District Court of Amsterdam issued an arrest warrant, and that was the basis for extradition under the old 1870 Act. Now, I do just want to turn this case up. The Van der Holst case is at volume 3 of the authorities bundle, tab 27. This, of course, is a case under the old 1870 Extradition Act. Under that Act, a request for extradition is not made by any judicial authority. It is made by a state and supported by evidence which may include an arrest warrant or other judicial decision. And in this case, there was an arrest warrant from a public prosecutor supporting a request for extradition, and the argument was that that didn't fall in the scope of the Act. If the court goes to page 2574, you can see the decision that was made. In the middle of the page 10 of the internal numbering, 2574 and the electronic numbering. It is conceded that the document is a warrant, but it is said it is not a warrant for the purposes of the Act, since being signed only by the public prosecutor is not a judicial document as required by the definition in section 26. There is, I think, a simple answer to that argument. The definition in section 26 of the Act is inclusive. A warrant is defined as including any judicial document authorising the arrest of a person accused or convicted of crime. There is nothing in the Act or the treaty which requires the warrant to be signed by a judge or magistrate. So the simple point was that the 1870 Act did not require a judicial decision. So the fact that a non-judicial warrant could support a request for extradition from the state takes one no further forward. We go back to the divisional court decision. Paragraph 35 we've already looked at. That's the paragraph where the divisional court suggests that the words judicial authority have two different meanings within the framework decision, and we say that cannot be right. The court supports that conclusion with the reasons that then follow. In the first place, paragraph 36, it is clear that the term judicial as used in the several member states does not refer only to a judge who adjudicates. Each member state recognises the threefold division of functions and powers within each state between the legislative, executive and judicial powers or branches of the state. It is a fundamental in each member state that the judicial branch is independent of the executive and legislative branch. Although no member state should for a moment consider that its Ministry of Justice was part of the judicial branch, many states, as is clear from the judgment in Shisa, consider that the exercise of judicial power is not confined to adjudicating. In some states, it encompasses the function of investigating, where this is entrusted to an investigating judge with the characteristics described in Medvedev's. So far, so uncontroversial. Although the status of a prosecutor is more debatable, a prosecutor does, in some member states, come within the term judicial authority. In some member states, the prosecutor is recognised as part of the corps judiciaire, and then there's a reference to the judicial council, comprising both prosecutors and judges, and a reference to the French example. There's a considerable diversity within the common area for justice as to whether prosecutors are judicial authorities. It's relevant to consider the status of the prosecutor, must enjoy independence in the decisions he must take, though the functions of a prosecutor are distinct and separate from those of a judge. And there, they actually quote the Bordeaux Declaration. Although a prosecutor is in many member states part of the executive, that independence gives the prosecutor special status. Now, with great respect to the divisional court, we say this paragraph 38 is wholly confused because although seeking to found on Shisa, the divisional court has failed to understand the point of Shisa, that Shisa is saying, yes, there is a diversity of practice in different member states, but there are limits to what is an acceptable judicial authority, and the limit is drawn by the requirement of independence from the executive and independence from the parties. And that principle is simply not drawn out at all by the divisional court. And of course, we say the Bordeaux Declaration is completely contrary to what is suggested here. So we say the first reason does not hold water. Secondly, says the divisional court, the explanatory memorandum, and this is the point about the original Commission proposal. Here they cite the explanatory memorandum, which was attached to the original Commission proposal that we've seen, and its reference to the term judicial authority not being limited to judicial authorities as such, but also including the prosecution services. And they refer to the 1957 Convention. You already have my submissions on that point, and we say, for the reasons discussed earlier, it is transparently bad. And indeed, the legislative history of the framework decision shows the opposite from what is suggested here.
So that is written in the context of the original
proposal.
Draft Article 3 with the definition?
Yes, that's right.
Do they actually mention that Article 3 was dropped?
No, they don't mention it. So the divisional court relies on that when it never made it into the final text. So then paragraph 40, thirdly, if the term judicial authority were confined to a judge who adjudicates, it is difficult to see what purpose Article 6 of the framework decision would have served. The article must have been intended to allow member states to designate authorities in their state which were judicial authorities, having regard to their own national law, given the diversity to which we referred at paragraph 38. Again, with respect, confused. because the purpose of Article 6 is clear. The purpose of Article 6 is that member states, from amongst the pool of authorities which are properly to be considered judicial, member states are to select the particular authorities whom they designate to issue warrants. The purpose of Article 6 is not to permit states to designate authorities that are not properly judicial. Now, they can designate them if they choose, but other states are not obliged in that case to execute their warrants. So again, we say that is a bad point.
So, I mean, that would give the French an opportunity to say, well, the juge d'instruction.
Yes, and the juge d'instruction passed muster in Medvedev and doesn't fall foul of the problem of independence. But this, as I've said before, is a simple, straightforward case because we deal here not with the juge d'instruction, but a simple common or garden prosecutor. Fourth, it cannot be said that the term judicial applies only to a judge who adjudicates. The different European traditions recognise that others, including prosecutors, can be included within that term for various purposes. It's therefore entirely consistent with the principles of mutual recognition and mutual confidence to recognise as valid an EAW issued by a prosecuting authority designated under Article 6. To do otherwise would be to construe the word judicial out of context and look at it simply through the eyes of a common law judge who would not consider a prosecutor as having a judicial position or acting as a judicial authority. Now, that in part seems to be a repetition of the reasoning of paragraph 38, but the suggestion that the placing of a limit on what is regarded as a judicial authority by reference to independence is in some way a parochial common law position is of course inconsistent with the case law of the European Court of Human Rights. It's a striking feature that the divisional court doesn't grapple with the centrality of the concept of independence at all here. The distinction it appears to be drawing is between a judge who adjudicates and some other sort of judge, and we say that is simply missing the point. Of course, anybody who makes a decision is adjudicating. The public prosecutor is adjudicating when deciding to issue a European arrest warrant and deciding that the proportionality test is satisfied. But what the public prosecutor is not doing is exercising a judicial authority because she is not independent. The court then cited the Goatley case for the point that the mere description of the executing official couldn't frustrate the purpose. And that in that case, they were satisfied that the prosecutor in the Netherlands performed a function as part of the judiciary. But again, we say that has no bearing on the position in Sweden. And then at 43, they expressed...
No, sorry, it's too quick for me.
Sorry.
42, Goatley. I mean, you're happy with Goatley, are you, on the basis that the particular functions there, as set out at the bottom of the page, are judicial?
My Lord, I'm in no position to comment on the precise position of a public prosecutor in the Netherlands. The key question in my submission would be whether the public prosecutor in the Netherlands is independent, both of the executive and of the parties. If he is, he qualifies. If he is not, he does not. Now, that's not a question that's addressed in Goatley, and it's not a question that's relevant to this appeal. The key...
Sorry to interrupt. Goatley was actually a conviction case where, if I recall rightly, there had been, according to the sheriff, some sort of decision. Perhaps he was referring to the original conviction by a court. But anyway,
that may be so. But my Lord, the decision in Goatley is in the supplementary bundle. If your Lordship would like to look at it.
I think it's at tab 17 as well, isn't it?
Unfortunately, my Lord, that's the wrong one.
Yes. Oh, I see.
The right decision in Goatley is in the supplementary bundle at tab 142. The key passage is at page 5914, paragraph 16. So in this passage we discuss the issues raised in the Ground Appeal 4. which seek to challenge the validity of the Part 1 warrant issued in the present case. The essence of the complaint is that the person who issued the warrant was Mr. S. Temple, described in the English translation as Chief Attorney General and Deputy Public Prosecutor of the District Public Prosecutor's Office in Uvarden. It's alleged he could not properly be regarded as a judicial authority. Then they record the submissions of Mr. Bovey at paragraph 16, submissions of the Lord Advocate, and then the discussion at paragraph 24. While we considered the authorities relied on by Mr. Bovey, in our opinion, none of them supports the approach he urged on us, which was to put into question whether the Netherlands had properly carried the framework decision into domestic law. In writing Scottish ministers, the court said it is to be taken that if the UK has decided to enter into extradition agreements with a foreign state, that will have been done only after the government of the United Kingdom has satisfied itself that the system of criminal justice operating in that foreign state is worthy of confidence. That was a bilateral treaty. Same principles apply a fortiori to a case under the framework decision. There's no merit in the argument the warrant is invalid because it's been issued by a person described in the translation as the Chief Attorney General and Deputy Public Prosecutor. The danger of Mr. Bovey's approach is to look at this description with Scottish eyes and say because a person so described would not be a judicial authority in Scotland, it must necessarily make the warrant he issued invalid. That is fundamentally wrong for a number of reasons. And then they say they have to have confidence that other states will act in good faith. They don't say the Netherlands have not acted in good faith. It doesn't say he wasn't properly convicted. They're not acting improperly, and the court should not seek to question the authority of the Chief Attorney General, look behind his appointment. Now, with respect, we say that none of those propositions is really of any relevance or assistance. It simply doesn't really begin to grapple with the point. And then at 26, they say that the carefully worked out scheme ought not to be frustrated by mere descriptions of the executing officials. Again, not really addressing the points that we make at all. And then at 27, they say in any event they had information and they think he performs judicial functions.
But begs the question as to what one has putting confidence in, doesn't it?
Yes, indeed. And in my submission, this reasoning just simply doesn't really take the matter any further. So.
I mean, it may be you don't want to say it, but it may be that your view is, or your submission is, that this decision is incorrect.
Well, my lord, it may well be incorrect. It's really not addressing any of the arguments that we've made. I mean, its reasoning, with respect, is not terribly impressive. Then, going back to the Divisional Court judgment, the Divisional Court addresses the case of Enanda, and in Enanda the court had concluded that it was for each member state to designate its issuing authority, and that couldn't be questioned by the English court. They say it's not necessary for us to consider Enanda further in the light of the principles which, with the benefit of much fuller argument, we've endeavoured to set out. Important to emphasise the issue in that case related to the issue of a warrant by the police for the service of a sentence. Maybe the circumstances relating to a warrant issued for the execution of a sentence are different. Although the approach in Enanda is one that will ordinarily apply, the designation under Article 6 does not, in our view, always compel the recognition by another member state as conclusive. If the authority is self-evidently not a judicial authority within the meaning of that broad term in the framework decision. And then they refer to the status of a Ministry of Justice, and that it had been said that the designation by some states, directly or indirectly, the Ministry of Justice was contrary to the terms of the framework decision. They say there appear to be no instances where the Commission has taken action. I've made the point the Commission doesn't actually have the power to take action. For example, if a warrant was issued by a Ministry of Justice, which the member state had designated as an authority under Article 6, it would not, in our view, be a valid EAW under the framework decision. Now, this passage we submit is important because we say here the Divisional Court rightly accepted that that under the 2003 Act, the mere fact that another member state had designated an authority could not be conclusive of the question whether that was a judicial authority. There is a question of substance, it's a question of precedent fact, which the English court has to consider. Is this a judicial authority or not? And if it is not a judicial authority, then the warrant is not valid. And we say that the Divisional Court was right to reject Enanda on that point. and was right to say that that is an inquiry that must be undertaken by the National Court.
As I understand it, the Lord Advocate, in his intervention, is challenging that proposition.
Yes, he is, my lord. But of course, the respondent is not challenging that proposition. Now, my lord, I don't know whether the message reached you. We received the Lord Advocate's submissions very late in the day, and I have asked to be allowed to reply to them in writing later.
Yes, well, if this had been a live issue, so far as anyone in this court was concerned, I think we would have wanted to hear some oral argument about it, because I understand it. It's not.
I don't understand it to be challenged by the respondent. So, my lord, I'm in your lordship's hands as to whether you would like a short note from us on the topic.
I think that would be helpful.
But I mean, all you're going to say is that in Andrew, the Royal Advocate say that the Article 6 designation is conclusive.
And we say that's wrong.
You say it's wrong.
We say it's wrong as a matter of statutory construction in the 2003 Act, and we also say it's wrong to suggest that the principle of mutual confidence compels that result. And in that regard, we rely on the recent decision of the ECJ in NS, which is the decision under the Fundamental Charter of Fundamental Rights, dealing with extradition to Greece, which overruled the decision of House of Lords called a case called KRA. But I can put in a short note on this topic. It's interesting at paragraph 47 that the Divisional Court accepts without hesitation here that a warrant issued by a Ministry of Justice would not be a valid warrant under Part 1. And that's interesting for two reasons. Firstly, because, as this court has seen, there are a number of member states that have designated their ministries of justice to issue warrants, which indicates that the implementation of this decision is not satisfactory. Secondly, it's interesting because it invites the question, why does the Divisional Court have so little difficulty in concluding correctly that the Ministry of Justice is not a judicial authority? And the reason in my submission is that it is incompatible with the notion of what a judicial authority is, that a judicial authority should be a branch of the executive. The essence of judicial authority is independence from the executive. But once one accepts that, one cannot escape from the second half of the equation, which is that it is equally of the essence of judicial authority that the judge is independent of the parties.
And
the nemo iudex rule.
Sorry. And the reasons they give in the middle of paragraph 47 is it would self-evidently not have been issued on principles universally.
Yes, accepted in Europe.
And that is the reason.
Yes.
And that's one you embrace wholeheartedly.
That is, and indeed, my lord, it's the point that at the outset of my submission I said, really, is the beginning and end of this case. It is a principle universally accepted in Europe and for over 1,500 years.
But if you look at paragraph 36,
36, my lord.
In their judgment, the last sentence is the key as to what they're referring to as fundamental principles, and I don't see, is there any reference to the principle nemo iudex anywhere in this?
No, there isn't, my lord.
No.
But we submit that it is very difficult to see that principle as in any way less fundamental than the principle of independence from the executive. They are the two key elements of what a judge is.
I also had some difficulty with this proposition that it's only if self-evidently the particular body is not a judicial authority that you go behind the designation.
If you need evidence,
once it's challenged, then surely it must be for the court to consider the merits of the challenge.
Lord, but we respectfully would agree.
I'm sorry, I mean, a public prosecutor you accept who is independent of the executive, but not of the parties. Is that the point?
Well, my lord, the position will be different in different states. It does appear that there is a decent degree of functional independence for the Swedish public prosecutor from the executive, but that the Swedish public prosecutor performs an adversarial function, which makes her a party. And that was the conclusion of the European Commission on Human Rights in the Swedish case. And we say there's no reason to depart from that. There's no suggestion that is wrong, that analysis is wrong.
I mean, would it be the same if we designated the CPS?
Yes, my lord, it's impossible to see how the CPS could be a judicial authority.
Independent of government, but it's a party.
It's a party, yes. And when you look at the type of decision that the prosecutor is being asked to make, in this case, the prosecutor is being asked to exercise a judgment is it proportionate to require this man's extradition in a situation where he has not been charged with any offence, where he is offering voluntarily to be interviewed by video conference, and where he's being required to leave his home and travel overseas. But of course, the prosecutor is the person who's investigating the allegations, and the prosecutor has an interest in wanting him there. And so how can the prosecutor make an impartial decision about whether it's proportionate to extradite him? In no way impugns her good faith. It is a functional problem that a person who's a party cannot be an independent, impartial judge. It's just, it's a basic fact.
Presumably it's not just a question of substantive impartiality, there's also a question of whether they appear to be.
Yes, of course.
Appearing.
Of course, my lord. And your lordship has my references to the Frome case, the Kander and Malaya case, and Pinochet. The principles are so familiar that there's really no need to retread the ground again. And of course, the Nemo Iudex rule is normally invoked in its extended meaning to deal with judges who are either actually biased or, more often, where there is the appearance of bias. But this is the core meaning of the Nemo Iudex rule, that the judge cannot simultaneously be a party. And the Frome case is interesting for that, because that was an analogous situation, that if you've participated in proceedings as a party, you cannot exercise a judicial function in relation to those proceedings. And that's the principle that goes right back to Roman law, on a European and not parochial common law basis.
Where's the reference in Justinian, since you're insistent on
my lord, I know, it's in our case. I obtained it from a textbook. It's tab 167, the supplementary bundle. Miss Law was sent to go and find the original one, and was told by Lincoln's Inn that they had two copies, an old edition and the new edition. When she arrived at the library, she discovered that the old edition was a 14th century manuscript, and the new edition was a 15th century manuscript. That is the reason they have not been photocopied. But the reference is at tab 167 in Latin and in English. If we can just return to the divisional court judgment. We were at paragraph 48, and here the point is simply the role of soccer. And again, we say here the divisional court was right, that the role of soccer is simply to certify that the issuing authority has the function of issuing EAWs. It does not certify it's a judicial authority. The judge, in performing the duties imposed by sections 64 and 66, must determine whether the authority is a judicial authority. And so they say it's right that it was raised in the extradition hearing, and we respectfully agree with that. Now then, finally, paragraph 49. And here is a fascinating part of the divisional court's judgment. Because what the divisional court says at paragraph 49 is this: although in our view no challenge can be made to the validity of the EAW issued by the prosecutor, it is necessary to consider whether the EAW should be accorded more intense scrutiny as a warrant issued by a party to the proceedings. That might be the case where it had not been subject to the impartial scrutiny of a judge in the member state of issue. Although a prosecutor would ordinarily act independently in the decision to issue the EAW and in pursuance of what would in the terms of the framework decision be regarded as a judicial function, the decision is that of a party to the proceedings which has not been subjected to the impartial scrutiny of a judge. It would therefore be entirely in conformity with the principles of mutual recognition and the promotion of mutual confidence between judges and citizens to recognise that circumstances can arise in respect of an EAW issued by a prosecutor as distinct from a judge, where it's necessary for a court to accord more intense scrutiny to such a warrant. Mutual confidence, particularly the confidence of citizens in the operation of the EAW system, is not enhanced by according to such an EAW the deference that would ordinarily be accorded to an EAW issued by a judge who is bound to take into account the interests of both parties to the proceedings. Now, we say that is a fascinating and revealing passage. because it shows the judge's deep unease with the notion that the party is the judge. But since he is determined to uphold the validity of the warrant, he seeks to extricate himself from his difficulty by dealing with it by suggesting a more intense standard of scrutiny. But what he's actually expressing here is that this is not a valid Part 1 warrant. It's not in accordance with the safeguards which the United Kingdom Parliament concluded were necessary in order to ensure the maintenance of mutual trust and confidence in the operation of this system.
I mean, what sort of things do you think they had in mind? Because I'm not quite sure what matters would be subject to more intense scrutiny here
it's
than would...
It's an extraordinary proposition and demonstrates the incoherence of the divisional court's approach. Of course, we've already seen from the House of Lords that complexity and lack of certainty are to be deplored in the operation of this regime. And yet the approach for which the divisional court contends is calculated to lead to uncertainty. And of course we submit the same is true of the approach of the respondent on this appeal, because the respondent on this appeal with respect has offered no coherent principle by which you would distinguish a judicial from a non-judicial authority. There is no clear test set out anywhere, either in the divisional court judgment or in Miss Montgomery's printed case. Then at paragraph 51, there is the point about the Svea Court of Appeal, and your lordships already have my submission on that the Svea Court of Appeal has not in any way endorsed the issue of an EAW. The Svea Court of Appeal has taken a different decision to uphold a detention order that is not the same as an order for extradition. It's not the same as an EAW.
If the court had approved the issue, then I suspect you'll be standing on a rather technical point. Nonetheless, it was still issued by the wrong body.
Yes, yes. But that is not the situation in this case. My lords, my lady, unless I can be of any further assistance, those are the submissions for the appellant, and we invite the court to allow the appeal.
Thank you very much. Mr. Summers?
I'm sorry, can I just be... What? Sorry. Can I just be clear? Paragraph 28, the Statement of Facts and Issues. I mean, what did the Court of Appeal in Sweden decide? That the domestic arrest was proportionate?
The Svea Court of Appeal upheld the order, a domestic detention order.
I know.
Yes.
What does that mean? I mean, were they alive to the fact that he wasn't there and that they'd be applying for an EAW and all the rest of it?
Well, the Svea Court of Appeal was not concerned with the question whether he should be extradited. Simply concerned with the question whether, if he was in Sweden, he should be detained.
A domestic detention order in absentia is not something that...
no, well, it means if he enters the country, he can be arrested. But the Svea Court of Appeal was not deciding or purporting to make any decision about the issue of an EAW or whether such a course would be proportionate. That was a decision that was for the prosecutor.
I mean, you were saying half an hour ago, by agreement, apparently, that it's routine in the Swedish case that there will be a domestic detention order before an EAW is applied for.
Yes, but also, my lord, as we saw from the Swedish evaluation report, there is a separate exercise of discretion that must be taken by the Swedish prosecutor, which is whether the EAW will be proportionate, looking at all the circumstances, including the personal circumstances of the individual, their family situation, the seriousness of the offence, a range of factors, the age of the individual, and so on. So it's a completely separate exercise of discretion from that which was undertaken by the Svea Court of Appeal.
I follow that. But all we take, therefore, from the Court of Appeal's decision is that they thought that for the purposes of a domestic detention, there was enough in the way of reasonable suspicion.
That's right, that he could be detained in Sweden.
of the offences, and they
Yes.
reduced the level of one-off.
Yes, that's correct, my lord.
Okay. Thank you.
Are there any other questions?
There is a reference, I haven't read all this material, but page 275, where the Court of Appeal upholds the decision to detain, it does say, decided he will continue to be detained in absentia upon suspicion. And then it says the international search and the European arrest warrant will be amended to conform with the detention order. Is that simply
I'm
recording?
sorry, I'm not sure where your lordship's looking.
275 in appendix part 1.
Hard copy.
Do you know what this is? It's a letter.
Maybe that's simply recording something which the prosecution has said, because the challenge appears to be into the arrest warrant and whether there was probable cause.
I'm told this is the prosecutor's website, my lord.
Oh, I see. I see. This is a press announcement.
Yes, it's a press announcement by the prosecutor.
Thank you.
It also says he
That illustrates rather neatly the problems if a prosecutor seeks to exercise judicial authority.
Thank you.
says he should continue to be detained, but at that stage, Lance said he was abroad. All right? Very odd.
Continue to be searched for.
What?
I think the reference is to the reduction in the charge. I'm sorry, my lord, I'm at a slight disadvantage not having been in this case below, but...
Yes, actually the decision is 445.
Yes, page 445, my lord.
Yes, that's helpful.
Yes. Yes, my lord, that is... Yes. And your lordship can see that there's no consideration of the sorts of issues that would be relevant to proportionality of an EAW.
In absentia
Yes.
simply means ex parte, as I understand it, not abroad. Because if one looks at 447, where there's an application for permission to appeal, the ground is it can be the question of whether it can be regarded as a transgression of the principle of proportionality to issue an arrest warrant for someone because of the danger he will flee, in that he didn't abscond.
Well, he had already left
Yes, he
Sweden.
had.
There were written submissions put in on
Yes.
his behalf.
Yes. Now, well, then I'm not quite sure what in absentia means, whether it means simply ex parte in his absence.
My lord, I'm not clear. For my purposes, the only point that matters about this is that it simply doesn't address the issues that arise in relation to the EAW.
Thank you. Yes, Ms. Ross.
I was going to start with the proposition Ms. Rose regards as being self-evident, that an investigator or a prosecutor cannot exercise judicial authority because they are partial. And I'm going to answer it by drawing attention to this most significant issue, namely that one has to ask that question in a particular context. And the relevant context requires you to consider the circumstances in which power or authority is being exercised. If power or authority is being exercised where adjudication is required between two contending parties, clearly a decision cannot be rendered on that by one of the parties. It must be rendered by an independent, impartial figure. But the difficulty is that the measures about which Mr. Assange complains are not measures which involve adjudicating upon an issue in which there are two contending parties, but adjudicating upon an issue in relation to which the interests of only one party is under consideration. Because what is an issue here is whether there should be an order for the detection and arrest of Mr. Assange with a view to his detention for the purpose of bringing him before a court and subjecting him to a process of extradition. That is necessarily a decision, an adjudication that will be made almost inevitably throughout Europe by a party, whether it is a public prosecutor or whether it is a policeman.
Public prosecutor or who?
Or a policeman.
Or a policeman?
Yes. The decision whether to arrest somebody normally is made by somebody who might be regarded as being partisan. That's what happens throughout Europe.
But we're concerned not only with the question whether to arrest, but whether to seek their arrest abroad and to bring them over.
Yes. There are two components. One is the decision to seek arrest. That will inevitably be made by a party. It's not something where any prior independent, impartial adjudication is required, because it's merely the way in which the criminal process starts in almost every case. And that's why Article 5.1, for example, of the European Convention does not impose any obligation upon the person effecting the arrest or seeking extradition to be independent or impartial. All that is required is where the arrest is effective for the purpose of domestic prosecution, that they are then brought before a person who has a power to adjudicate in an impartial and independent fashion. And so the flaw in the whole approach taken by the appellants to this case is they say, well, judicial authority must mean somebody independent and impartial, but the answer to that is not necessarily. If the judicial or the part of the administration of justice that is being invoked and decided upon is in fact the preliminary part, which depends entirely upon the decision of a party, namely a prosecutor or investigating officer responsible for commencing the process of investigation and process. And so there is no reason, if one looks at the exercise of power here in issue, namely the application for somebody to be arrested and taken into detention, there is no basis on which you can say that necessarily must require the decision to be made by somebody who's impartial. The reverse is true.
What do you say the words judicial decision mean? And in particular, what's the word judicial mean?
Judicial means appertaining to the administration of justice. It means associated with the judicial process, but it clearly does not refer to only adjudicative decisions in the sense of final decisions upon an issue joined between parties.
So, I mean, on your interpretation, it's actually a completely unnecessary word. You could strike it out. It's obvious this is all about arrest and surrender with a view to either execution of a custodial sentence already passed or conducting a criminal prosecution. It says so. The word judicial could simply be deleted.
No, I would split it. It plays a role. It demonstrates that the decision must be taken as part of the administration of justice, that it can't be a purely arbitrary decision taken without reference to any judicial context.
Well, can it be taken by a Ministry of Justice?
It really depends upon whether the Ministry of Justice is there exercising a purely executive political role, or whether it is exercising some function in connection with the administration of justice. Now, I'll give you a specific example, which I hope will illustrate where we submit the line is to be drawn. Clearly, if we take a ministry that has, undoubtedly, because it's part of the executive of any state, a political role, and if it decides to apply for the extradition of Mr. Assange because it deplores his politics, and in an avowedly political move makes an application for his extradition, that would have no judicial context. If, on the other hand, as is commonly a feature, the Ministry of Justice has, as part of its remit, the responsibility for allocating people to prisons and, in cases where they don't go into custody immediately upon conviction, determining the day upon which they should start their sentence and where they should start it, there often will be part of the Ministry of Justice that is responsible for saying, prisoner A, you've been convicted of this crime, you must report to this prison on that day in order to start your sentence. And if he doesn't turn up, often it will be that ministry that will issue an order for his detention in order to give effect to that prison sentence. Now there, one can readily see that that part of the Ministry of Justice is playing a direct role in the administration of justice in ensuring the execution of sentences passed by the court. So one does need to look very carefully at the context and determine whether or not the decision to seek arrest or to seek extradition is being taken in the context of the due administration of justice, or whether it's being taken in some other guise or for some other purpose.
But the application for extradition or surrender is in relation to a specified offence, is it not?
It is, or for a specified conviction.
Yes. Well, that will always be associated with the administration of justice, then, will it not?
Not necessarily, my lord. If, for example, one was able to say of a particular body that the application was being made not for the purpose of the administration of justice, but not where there was any domestic power vested in that body to perform a function with the administration of justice, but merely for some non-legal purpose, then you would be able to challenge it. But and I accept it may mean that it, in fact, provided the domestic law vests a function in connection with the administration of justice in a body, it doesn't really matter who that body is. It could be part of the Ministry of Justice, it could be a police board, or it could be a prosecutor.
I'm sorry, no, please continue.
And in my suspicion, that there's nothing in the suggested need for impartiality that would do violence to the proposition that nevertheless the person is still protected in relation to all their fundamental rights, because firstly, under the framework decision, as I will show this court, there is always a requirement for there to be an underlying domestic order justifying the process that is issued as part of the European arrest warrant. So, for example, in accusation cases, there is always a requirement under Article 8 of the framework decision to provide details of the underlying domestic judicial decision justifying the domestic process, or the conviction justifying the domestic process. So, firstly, in any case where the EAW is issued by somebody who might be regarded as a party, there is a requirement for a prior valid domestic judicial decision, either by way of conviction or order. And secondly, so far as the Article 5 rights with which Ms. Rose is so concerned, there is also a requirement under both the framework decision and under the Act, once the person is arrested, for his rights under 5.3 and 5.4 to be respected. Under 5.3, there is an obligation under the framework decision and under the Act for him to be brought to court, and for the legality of detention and the need for continued detention to be considered. And in addition, there is the requirement thereafter, in terms of Article 5.4, for a court to assess the legality of his detention. So not only does the Act and the framework decision contain within it clear indications that fundamental rights are to be protected, but it is also, in my submission, perfectly consistent with the process of extradition both before the framework decision and after it, that the core decision, should this person be arrested and should we seek his extradition, is capable of being taken by someone who is a party, is normally taken by someone who is a party, and...
Not in this country.
Well, my lord...
For a European arrest warrant?
For European arrest warrant, no, but as a matter of history, the request for two things. Firstly, a European arrest warrant can only be applied for where the CPS or a designated public prosecutor makes the application. There's no power in anyone else to make the application to the court, which may issue the EAW. So there has to be a prior prosecutorial decision before we can issue an EAW. After that, the matter goes to one of the designated courts, and the court is indeed the body that issues the warrant formally. But it requires a decision by a prosecutor to initiate that process.
You've obviously got to set the thing in train.
Yes.
It will be required forever. I mean, it's always going to be a prosecuting agency or the police that takes the decision, as you pointed out.
Yes.
But as my lord points out, here you have the added requirement of the perceived necessary added safeguard of going to a court.
As I think at least one of the justices pointed out, in this country and in the Republic of Ireland, the tradition has always been that any warrant of arrest is a document that is, at least in modern times, a document issued by the court.
Yes.
As compared to that, throughout the continent, as you've seen from the countries that have made designations under Article 6 of the framework decision, and this is not a modern phenomenon, this is the way they've always operated. At least 8 of the countries who've made designations are countries in which only a prosecutor will issue arrest warrants. And in those circumstances, it's very difficult to